Hi folks, today I have for us a video from Wildman Audits, where he goes to the appellate courts to argue his case over a protection order. But before we start today's video, as always, a big thank you to all of my current and new channel members and subscribers. Without all of your support, I couldn't keep the channel going, so I thank you all personally from the bottom of my heart. And if you're new to the channel, please subscribe to the page. Leave a like and a comment because it helps me with the algorithm. Don't forget to check out my second channel and the podcast. With all that being said,
my name is Cody Henderson. I am the appellant, and I was the respondent to a civil protection order, which is the underlying case that is being appealed here. And the civil protection order was filed by a police officer who erroneously asserted that I had caused him and his family some type of threat. I don't know the specifics beyond that.
Let me just ask you, Mr. Henderson, in your brief, you stated that when they tried to serve you with the copy of the protection order, you said you declined to contract with the officers. What do you mean by contract?
I mean that...
that's right. This guy goes full sovcit in the appellate courts. But not only that, I've covered him twice on this channel before. The first was in June 18th of last year, where he was being given this protection order in the courthouse and chose to stick his fingers in his ears and scream at the top of his lungs, fighting the cops and getting arrested. The second time was when he was trying to do FOIA requests after hours and being told to leave the building. Yes, our friend here is not only a hippie, but a frauder and a sovereign citizen.
I have the fundamental constitutional right to contract, to enter contracts, and to not enter contracts. So that means whenever someone comes up to enter an agreement with me to talk, that is a contractual agreement to speak to each other. And
What the fuck are you talking about, man?
I meant that I did not choose to contract with those officers. I did not choose to speak to them in any effect of the matter. And I think the key difference here, because a lot of people look at this situation and they think of it in a criminal context. In a criminal context, it would be different. The officers obviously would have probable cause of a crime being committed, which would allow them to detain me and to violate or temporarily put my Fourth Amendment right on hold while they're detaining me for the crime. Now, in this case, it's completely different because this is a civil protection order, so it must follow Ohio civil rules of procedure. Clearly, in my brief, I lay out the civil rules of procedure that apply, which is Rule 4.1, capital B2, lowercase a and lowercase b. Those are two separate subsections. Lowercase a states that the sheriffs do have the ability to come up and serve someone with civil process. But section lowercase b states if that service is refused, which I did, I refused it, then they must follow a whole different procedure which requires them by law to send it certified mail, which they did not do. Instead, they arrested me for refusing it, which is
Shenanigans. Shenanigans. And we're calling shenanigans, folks. Due to the fact that our fraud or sovereign citizen hippie friend here is wrong, I will have to explain it. Section B does state that a sheriff can deliver a civil protection order to a person as long as it has been issued through a higher court, such as a circuit court or a county court. But if it was issued through a lower court, like the city or municipal courts, it is delivered by a bailiff. Now, something else he is trying to imply is that since he did not get served properly or refused the service, that it should have been sent to him through certified mail. That's not necessarily true. When it comes to the sections of serving a protection order, or civil protection order in this case, in Section A, it does say it can be sent through certified mail or through a certified serving service, but unless it is specifically specified in its ordering on how to serve it is usually done through the bailiffs or sheriff's offices.
It's not okay, and it's a violation of my constitutional rights, and a 1983 lawsuit is going to come from that, but that's a separate issue.
Mm-hmm.
The issue here is my constitutional rights were clearly violated by the people who claim they served me according to law. They did not serve me according to law.
Well,
I just
the trial court's record indicates that you're served. I know you're saying you weren't, but the trial court's record. Let me finish. The trial court's record reflects that you were served. And there was a hearing where you could have raised the issues that you raise now on appeal, but you didn't appear for that hearing.
I didn't get notice of the hearing.
But you didn't raise that in your motion for new trial.
I did raise it in my motion for new trial. I raised the fact that I wasn't served according to law in my motion for new trial.
So with the civil protection order, not the notice of the June 17th hearing.
I didn't get notice of the June 17th hearing, which came with the civil protection order. The civil protection order itself had a hearing date all attached with it and everything with it. I didn't receive any of that paperwork.
That hearing was continued and a new hearing was scheduled.
I raised the fact that I did not receive any mail from them. They sent the mail to the wrong address, and I didn't receive any of those notices. Furthermore, there's an affidavit that proves that and asserts that, and there's no evidence that can rebuttal it. Further than that, these officers are already caught on body camera, violating my constitutional rights and never serving me that paper. This same sheriff office has a body camera policy to have body cameras on when they're interacting with the public and doing business. So if they did serve me that, they would have to have recollection of it on body camera. Does not exist because they never served it to me. They arrested me, took me to jail, strapped me to a restraint chair, and tortured me because they think that that's the proper way to punish someone for not obeying their orders.
Now, I hate to be the bearer of bad news here, but I have footage of him being served. It's him rejecting and wanting to act like a toddler. It's the issue here. Not to mention the fact that he was actively resisting arrest, he was making threats, being combative, and even in the back of the cop car, he was making threats and being hostile, meaning once they got to the jail, to keep him from harming himself or other staff or inmates, they placed him in a restraint chair. That is not torture. That is a means so you can calm yourself down before you end up getting more charges. I'll be posting a link to the original arrest video in the description box.
In relation to a civil summons, which is not okay, and that's not the proper procedure to law. Furthermore, I'll let the other side go, and I'll come back.
Okay. Any other questions?
No.
Excuse me. Good morning. May it please the court. Mr. Henderson, my name is Ashley Hetzel on behalf of Appellee William Jason Lawless. What's required by law for a civil protection order is the notice and the opportunity to be heard. Mr. Henderson received notice of the protection order and the hearing, and he had an opportunity to be heard at that hearing. That's what the trial court had in front of it, that the sheriff's deputies properly served Mr. Henderson with the protection order and the notice. At the hearing, Mr. Henderson, for whatever reason, chose not to appear. It wasn't until after the hearing had been concluded that Mr. Henderson called the court to let them know that he was running late to the hearing.
And the plot thickens!
Like I mentioned in our brief and just now, the hearing had already been concluded.
Can we actually consider the trial court's statement that he called after the hearing?
Objection hearsay.
This isn't a trial. This is just on appeal. It's just pure arguments. So she can make any presentation, include hearsay if she wants to. That's okay here.
Okay, hearsay is part of evidence. Okay.
Because I'm getting into my laughing pose. Moron!
Yeah.
I believe that the trial court was in the best position, and it's within their discretion to consider evidence. And so, based on what was in front of the trial
Well,
court.
but my question is, it seems that the evidence you're talking about was offered by the trial court itself in its decision. is that an appropriate role for the trial court to play in putting that statement on the record?
We believe so. We believe that the trial court's in the best position to consider that evidence and the credibility. And it was also in front of the trial court that the service had been perfected on Mr. Henderson, and that he had notice of the hearing and an opportunity to be heard at that hearing.
Okay. How do you respond to his argument under the B subsection that the officers, he says, didn't follow the correct procedure?
Mr. Henderson raised those arguments in his motion for a new trial that was filed with the trial court. And so my response is that the trial court, it's within its sound discretion to consider those, and the trial court chose to deny the motion for a new trial.
So what is your position as to what the police officers, how they served him? He's claiming that he refused and there's another procedure that wasn't followed.
My response to that is that the sheriff's deputies had returned the service to the trial court as being perfected. And that's what the trial court considered, is that the service was perfected.
Okay. So you're saying essentially that there was a document in front of the court that said it was properly served. He's saying on appeal that it wasn't properly served.
That's correct.
Are you saying that's not in the record?
No, it's in the trial docket, number 8, is that the notice to serve was returned and executed on Mr. Henderson on May 21st, 2024 by the sheriff's deputies.
And then the burden shifts if somebody wants to challenge service. The person who's challenging the service would have to bring forth evidence that they weren't properly served.
Here we have even more proof of his own stupidity. Now, if you look at the body cam footage from him being arrested in the courthouse, the date on the body cam footage says it took place May 21st of 2024, meaning his arrest denied him his own service of the paperwork, meaning the paperwork had to be returned to the court. Seeing as the sheriffs did exactly what they were supposed to according to the law, he really doesn't have an argument to stand on. If he would have simply accepted the paperwork like a responsible adult instead of throwing a tantrum like a child, this probably wouldn't have happened and he could have had his day in court.
Correct.
Okay.
Finally, I would just like to make the last point, because Mr. Henderson did begin to speak as to the merits of the civil protection order. And I would just like to point out that his opportunity to appeal the merits was filed, if at all, 2 days late. So he has foreclosed on appealing the merits of the civil protection order. And if the court has no further questions, he would rest. Thank you, Your Honor.
All right. First of all, I did rebut the notice from the sheriffs that it was served on me, and I did that in my motion for new trial because I didn't get the opportunity of a hearing as I should, and I think that my Fifth Amendment right and 14th Amendment right to due process has been clearly egregiously violated here because I have not gotten the right to a hearing, and I proved that in the body camera footage that I included and attached to my motion to new trial. Which
you have to understand, when you motion for new trial is not challenging the service. When you're motion for new trial, you're saying you just want the opportunity to be heard, that you didn't commit these acts. So it's almost acknowledging that you got served.
No, my
Congratulations, you played yourself.
motion for new trial was me motioning for new trial based on the fact that the order was issued contrary to law, and I was just exerting my remedies as appellate courts generally recommend for people to do in the trial courts, is to exert their remedies before bringing something before the appellate court. So I did that out of honor of you guys. I tried to file this motion for new trial to have it dealt with on the trial court level, hoping that the judge would realize that there was an egregious violation made and there was a mistake made, and that he would give me the actual right to a hearing that I, as an American, have the right to. But unfortunately, he didn't do that. Instead, what he did is he responded with an entry that says that the court finds that the respondent was served according to law despite his efforts to thwart said service. This is hostile language used against me. I did not thwart said service. I exercised my constitutional rights.
Okay, but you did reject service by getting physically combative with 3 sheriff's deputies, by making an obscene amount of noise in the hallways of the courthouse, not to mention you were also physically combative in resisting arrest and making threats and having a hostile nature while being placed and inside of the squad car. So the judge's definition of what happened is actually accurate. Congratulations, you played yourself again.
To twist the words and act as if I am thwarting something by exercising my fundamental rights is egregious, and not only egregious, it's hostile towards me and prejudiced me massively. Furthermore, he goes on, and the rest of his reliance in the entire order is based on hearsay that he heard apparently from his clerk between a phone call that I had personally with his clerk. And with his clerk, this phone call did not say that. What I said is, I don't know when there's a hearing, but I heard from my current attorney there's a hearing in this case. Can you tell me when it is? She said, actually, it just happened 30 minutes ago. I said, can you get me together every record in the case? I'm going to pick it up in an hour.
Wait a minute. You had a lawyer, but your lawyer didn't tell you when your court date was? He didn't go to court and argue your motions or anything on your case to get this denied? Either you had a bad lawyer, which you need to go to the bar commission and have them deal with your lawyer, or you're making that up to the clerk. So, which is it? I mean, you can't blame everything on somebody else. If you had a bad lawyer, you have justification. You can make the argument that you would need a new case due to the fact you had ineffective counsel. But if you didn't have a lawyer, it explains so much.
Up there immediately, picked it up, and filed this motion for new trial as quickly as I possibly humanly could, within days. And I'm not an attorney, by the way. Okay? So the amount of work that I put into this is ridiculous. And really what I'm appealing here is I'm appealing this entry from Judge Bender here from the trial court that is completely based off hearsay. That's against the rules of evidence, first and foremost, for the judge to enter hearsay against me. For 2, the judge entering his own evidence as the practicing of law, which is a violation of Ohio Judicial Rule of Conduct 3.1, thou shalt not practice law. You can't practice law from the bench. That's a rule that goes back all the way to the Magna Carta. So we can take this back common law to the back of the beginning. But this is an egregious violation of my rights on multiple fronts, whether it goes to the sheriffs violating my constitutional rights when they didn't let me leave and they didn't let me refuse the contract and send it certified mail according to law. That's the first egregion of my constitutional rights. Number 2 is the judge acted clearly contrary to the law because he introduced his own evidence against me, which is biased and prejudiced me directly.
What a crock of shit. Have you ever heard more bullshit or drivel coming from somebody who's not even the president?
And he based his whole finding off of this thwart said service, this hostile language that he's using against me without any case law, without any citation to evidence. And as I said, I've submitted video that proves that I wasn't served properly. There's obviously prejudice by the judge. It's ridiculous what is in this order right here. I can't believe that somebody that went to law school wrote this, because my writings are far more intelligent and artful than to say someone thwarted said service by exercising their constitutional rights.
Oh, wait, you serious? Let me laugh even harder.
Never should I be seen as being thwarting a service by exercising my constitutional rights. The Constitution is the supreme law of the land, and if we don't have constitutional rights, we don't have law, period. So, furthermore, I would like to cite Briars versus United States. It is the duty of the courts to be watchful for the constitutional rights of the citizens. And that's cited in my brief. And it's also been reaffirmed in Boyd. So Boyd versus United States and Briars versus United States emphasize the same exact sentiment, that it's the duty of the courts, the absolute duty of the courts
Now, did you look up those two cases? Because I did. The Breyer case dates back to 1927, when the local police asked a revenuer to come help them with the search of a person's property that may have been manufacturing illegal moonshine. They didn't get a federal search warrant. They got a state search warrant or a local search warrant. But since they still asked him to come and he found evidence that they tried to use against him, the Supreme Court stated that they needed a federal search warrant and a unanimous vote. And the Boyd case has to do with the taxing of imported items and the confiscation of illegal contraband. So how does this affect you who were arrested for obstructing while you were being served a civil protection order? These two cases have nothing to do with that.
To be watchful for the constitutional rights of the citizens and against any stealthy encroachments thereof. This civil protection order, the order from Judge Bender, the way the trial court treated me and the way that I've not been given the opportunity of fair service is an absolute stealthy encroachment on my constitutional rights, on Ohio constitutional rights, my Fourth Amendment, my Fifth Amendment, my 14th Amendment, and furthermore, my freedom of locomotion when these sheriffs grab me up for no reason. So I think that I have every right in law to assert that I have the right to have this trial or have this case reversed and remanded back to the trial court where I can actually get the opportunity to address my accuser, address all of this, address this order from the judge that is based off hearsay, and actually go through this according to law, through the proper techniques and the proper citations that has been founded through common law and has been supported ever since. And so I'm a big activist of the Constitution, and that's why I've been targeted here.
Come here. Shut your stupid ass up.
And that's why this is all happening, is because I'm suing her client for $2.3 million for violating my constitutional rights. And the Judge Bender, obviously doesn't like that, if you can tell by his order that uses hostile language against me, and that further uses hearsay as the only basis to substantiate the claims of why I don't deserve a new trial. Furthermore, I've clearly proven in my motion for new trial that for every other reason, I do deserve a new trial. So for those reasons listed and the reasons in my appellant brief, I'm kindly and respectfully asking this court to stand for constitutional rights, to stand against stealthy encroachments as the Supreme Court has commanded, and to stand on behalf of the constitutional rights of the citizens and allow this to go through the court through the proper procedures. I'm not asking for a freebie here. It's still got to be remanded. I've still got to fight my way through this. I'm not asking for you guys to side with me completely. I'm just asking for an opportunity to fight this case. That's it. Thank you.
All right, any other questions?
No.
I have none.
All right, thank you. All right, appreciate both of you coming in here this morning. We'll take the matter under advisement and then we'll render our decision.
And this is where the video ends. I'm going to keep an eye out for the update to this video because this was entitled Episode 1. So Episode 2 must be even more intense and, well, full of sovereign citizen lingo and frauditor dipshittery. So if you guys like this video, please like, share, and subscribe. Leave a thumbs up and a comment because it helps me with the algorithm. Don't forget to show your support by sharing these videos and checking out the second channel and the podcast. With all that being said, be well, be safe, and I'll see you guys next time. And a special thank you to all members of the news team. Without all of your support, I couldn't keep the channel going. I just want to thank you all personally from the bottom of my heart. You guys mean the world to me, and I can never thank you enough.